Hi, good afternoon, everyone. Thanks for joining us today. My name's Katie Burrows. I'm a partner with PilieroMazza, and today that we are talking about some recent bid protest decisions that have been issued um, by GAO and the Court of Federal Claims that we think might be interesting and helpful to you for future procurements and just things to keep in mind if you do decide to protest. So thank you for joining us today. We can move to the next slide. So just to give you a little background about myself, I'm a partner in the government contracts practice. I lead the bid protest practice here at PilieroMazza. In addition to bid protests, I do handle all sorts of other government contract related matters, including claims, REAs, FCA matters, so on and so forth. It kind of runs the gamut. And also with me here today is my colleague, Eric Valle. I'll let him introduce himself.
Thanks, Katie, and thanks everyone for joining us this afternoon. My name is Eric Valle. I'm a government contracts attorney here with PilieroMazza. I also handle the full spectrum of government contracts related matters, and a large portion of my practice is focused on bid protests. So I look forward to discussing those with you in more detail today. Thanks, and we could go to the next slide, Katie.
So just a little bit about PilieroMazza. We are a full service firm. In addition to our government contracts practice, we also have a litigation group, a construction group, a corporate group, M&A, and also labor and employment. So if you have any of those needs, please feel free to reach out to us. You can go to the next slide, Kelly. So today we're going to talk about, just give you a little bit of a little overview on bid protests. We're going to talk about recent bid protest statistics out of both the Government Accountability Office and the Court of Federal Claims. And then we're going to dive into, I believe it's about 6 recent bid protest decisions, and then we'll give you some tips at the end. And if you have any questions, please enter them into the box and we'll answer them as we can. So with Eric, I'll go ahead. Sorry.
Yeah, thanks, Katie. So like Katie said, we're just going to start off today with a brief overview of what a bid protest is, where to file a bid protest, that will help give a little bit of helpful context for anyone not intimately familiar with the bid protest process before jumping into the cases. So we can go to the next slide here. So for anyone not familiar with a bid protest is a really unique thing in federal government contracting, what we're going to be talking about today. And it's a challenge basically to a procuring agency's actions in connection with a federal government procurement. As you'll see with the cases that we highlight today, these challenges can take a number of different forms, and there are a number of arguments that can be made in any given procurement. But bid protests, importantly, are different from size or status protests, the bid protests that we'll be talking about today, which challenge the size or socioeconomic status of the awardee. Those are handled by the Small Business Administration. We're not going to be discussing those decisions today. They're sort of on a separate track from what we typically think of as a bid protest. The two types of bid protests that we are going to be talking about today are pre-award and post-award protests. And we, typically categorize bid protests into those two different groups. A pre-award protest, we typically think of a challenge to the terms of a solicitation that the government issues, or to the sort of ground rules or structure of a procurement that the government intends to conduct. And in a post-award protest, as you may be able to tell from the name, that's when the government has made an award decision, and there's a protest typically by a party that has not been selected for award that believes they should have been selected for award. That's a typical post-award protest. And with that little brief overview, we can jump to the next slide. And so, there are multiple options of where to protest. We're actually going to be talking about the bottom 3 today. And when we think of a bid protest, typically we're in the realm of these 2 middle bullets here. We're talking about protests to the U.S. Government Accountability Office or the U.S. Court of Federal Claims. Those are the 2 most common forums where a protester will typically go. We are going to talk about one FAA procurement today, and that's when the Federal Aviation Administration conducts a procurement. The FAA has their own set of rules. They have their own set of acquisition policies and procedures, and protests of FAA procurement decisions go to the FAA's Office of Dispute Resolution for Acquisition, called ODRA. So we'll be talking about one of those today. We're not going to be discussing any agency level protests, but that is an option when you're dealing with an agency that is not the FAA. But those decisions are typically not made publicly available. They're made by agency contracting officers, and so those typically don't shape the bid protest landscape. They tend to fall in line with GAO decisions and what the Court of Federal Claims has said. And with that, I will turn it back over to Katie, and we can move on to the next slide.
Thanks, Eric. So next, we're going to talk about the recent bid protest statistics out of both GAO and the Court of Federal Claims. Kayla, you can move to the next slide. So with regard to GAO, in 2023, we saw a pretty large increase in the number of protests because of the CIO SP4 protests. There was a significant number of those protests, as many of you may recall or may have been involved with. So since those have now come to a close, there has been a decrease in the number of GAO protests, and they've fallen back in line with the pre-2023 numbers. So they've decreased by 11% from since 2023. As far as paths to victory, either corrective action or sustained protests, the effectiveness rate at GAO for corrective action is 52%, which has been a slight increase from what we have seen in the past. But it is what we as a firm, I think, have seen overall. And as far as sustained protests, at GAO, we've seen a 16% sustain rate, which is a slight increase from what's occurred in the past. Kayla, you can switch to the next slide. And just to kind of give everyone a quick overview on what the greatest number of sustained arguments have been at GAO, unreasonable technical evaluation, and whether that's your own proposal or quote or the awardee's proposal or quote, and then flawed best value or source selection decision, and unreasonable cost or price evaluations. Those have kind of been the big hitters, so to speak, at GAO. So with that, we'll turn to the Court of Federal Claims. Kaylee, if you want to switch to the next slide.
Yeah, and so the Court of Federal Claims is sort of your second typical option to file an initial protest. And the Court of Federal Claims also releases the protest statistics for each fiscal year in a little less detail than GAO, but there's still some interesting statistics over the past year that we've seen. And so the first is the number of bid protests being filed at the Court of Federal Claims has actually increased fairly dramatically over the past year. This was sort of an anecdotal stat throughout the year, but we now have the statistics on it, and there were 266 protests filed with the court in fiscal year 2024. That is a almost 100 protest increase from fiscal year 2023, when there were 169 protests filed with the court. There's also been an influx of new judges at the Court of Federal Claims over the last 6 years. And so really the makeup and the composition of the court has changed almost 100% over the last 6 years. 15 of the 16 judges that are not in senior status at the court are new within the past 6 years. One judge is about to turn senior status in the next few years. And then there are still 5 judges on the court who are in senior status. That means they're serving in their second 15-year term on the court. So really this influx of new judges and the increase in filings at the court has led to an exciting body of case law coming out of the Court of Federal Claims. I think maybe historically, the knee-jerk reaction whenever a protest came in was to start at the Government Accountability Office as the more expeditious solution. But again, anecdotally, I think as these procurements become more valuable to the contractors, as the stakes become higher, the Court of Federal Claims has actually been seen more as a first choice based on some differences in the procedure there, access to more record documents, and perhaps a more granular level of review by the new judges as well who've come in the past few years. And so with that, we can move on to the next slide. Just before we go on, I see one question in the box asking if the slides will be available after the presentation. They will, and our team here at PilieroMazza will get those out. All right, so the first case we're going to start with today is a case that really highlights or a set of cases that really highlights a disparity between the two protest forums that we've talked about, the GAO and the Court of Federal Claims, on a rule known as the late is late rule. And so with that, we can get to the next slide here. And so what this case really centers around, this e-simplicity case, is the late is late rule. That is a rule in FAR Part 12 and FAR Part 15 procurements. And that rule says that a late proposal, a proposal that's received after the submission deadline, is late. It will not be accepted. It will not be reviewed by the agency. You can't do it. There are, however, a few limited exceptions to the late is late rule. And those limited exceptions say that the late proposal will not be considered unless it's received before the award is made, the contracting officer determines that accepting the late offer would not unduly delay the acquisition, and the offer meets one of three additional terms outlined in the various FAR clauses, 52.212-1 and the corresponding section in 52.215 for FAR Part 15 procurements. The first exception that's outlined there has come to be known as the electronic commerce exception. And that exception says that if the proposal is submitted basically via email, that it will be considered, or it can be considered, if it's received at the initial point of entry to the government infrastructure, not later than 5 p.m. one business day before the actual proposal submission deadline. So whatever the deadline is in that solicitation, if it's May 8th at 5 o'clock p.m., to qualify for the electronic commerce exception, the proposal needs to hit that initial point of entry to the infrastructure on yesterday at 5 o'clock p.m. to be considered. The second exception outlined in the FAR is the government control exception. And that government control exception basically says that if the proposal is at the government installation designated for receipt of offers and under the government's control prior to the proposal submission deadline, let's call that today at 5 o'clock p.m., then the proposal may be considered, even if it doesn't actually reach the contracting officer or the designee at that point prior to the submission deadline. And these two exceptions have created a split in the case law between the GAO and the Court of Federal Claims over the past 20 years. The GAO says that an electronically submitted proposal, a proposal submitted via email, can only qualify for an exception to the late is late rule under the first exception, the electronic commerce exception. That's the only one that applies if you email your proposal. The Court of Federal Claims, on the other hand, has said for the past 20 years that the electronic commerce exception is not the only exception that can apply to an emailed proposal. It is one exception, but the government control exception can also apply to an electronically submitted proposal. And there's been a split over that for the past 20 years. And so e-simplicity was actually a case that originated in 2021 timeframe, and e-simplicity submitted their proposal via email prior to the due date but not one day before by 5 o'clock p.m. They submitted that proposal via email. It hit what was called the destination server for the government agency that was conducting this procurement. But due to the size of that proposal, which will be discussed here in a second, that destination server never passed the proposal on to the contracting officer's inbox and rejected the email due to the size limitation. The agency, the Navy, determined that eSimplicity's offer was late. It determined that it was not submitted prior to 5 o'clock p.m. the day before, and therefore it would not be considered per the FAR. And eSimplicity went to the Court of Federal Claims and argued that its proposal should have been accepted and that the agency erred in, number one, not stating the size limitation requirements for the proposal in the solicitation, that the agency applied an unstated evaluation criteria and not accepting the proposal for exceeding a certain size limitation. And number two, that the agency erred by not considering whether the proposal could be accepted under the government control exception. And the Court of Federal Claims, consistent, although for slightly different reasoning, with the precedent at the Court of Federal Claims, found that the government control exception can apply to emailed proposals. There wasn't a determination that the government control exception, all of the factors were met in this case, but it determined that the government control exception can apply, and that by not considering that, the agency had erred. The court also found that the agency applied unstated evaluation criteria in rejecting the proposal because the solicitation did not explain what the size limitations were. And then the Court of Federal Claims remanded the case to the agency to make certain determinations consistent with its opinion, at which point the agency issued an amended solicitation and re-procured the work, actually awarded the contract to eSimplicity. The government then took the case up on appeal to the Federal Circuit to really determine the question as to whether the government control exception can apply to emailed proposals. And there was a lot of debate within the government procurement community that the Federal Circuit would finally end this 20-year split between the GAO and the Court of Federal Claims as to whether a late emailed proposal could qualify under the government control exception or whether the e-commerce exception is the only exception that could apply. Unfortunately, the Court of Federal Claims, or the Court of Appeals for the Federal Circuit, did not resolve the circuit split. That split still remains in the law because the appeals court dismissed the government's appeal as moot, finding that by amending the solicitation and reissuing it, allowing revised offers, and ultimately awarding the contract to eSimplicity, that the government had mooted the appeal, that the issues about the government control exception and the e-commerce exception were no longer live issues. Now, the Federal Circuit actually on appeal made some comments that the FAR Council should really be the ones to address this circuit split, not the Federal Circuit, which may have played into the decision and the finding that was ultimately made. But for now, the split remains. So if you have a late emailed proposal that you think was under the government's control prior to the deadline for receipt of proposals, but was not submitted by 5 o'clock p.m. one day before that submission deadline, the most likely place that you will succeed is by filing your protest in the first instance at the Court of Federal Claims. And Kaylee, we can go to the next slide here. And so just to highlight that split, we've included another case here from the GAO. This decision was issued after the Court of Federal Claims issued its initial decision in the eSimplicity case, again, finding that the government control exception can apply to emailed proposals. And in GAO's most recent case, Guidehouse, in January of 2024 on this issue, the GAO really reiterated its rule that its belief, its read of the regulations is that the first exception, the electronic commerce exception, is the only exception that can apply to an electronically submitted proposal, that you cannot apply the government control exception to an electronically submitted proposal to save that proposal if it was late. And in this case, it's quite interesting here. The protester submitted 6 emails, again, 2 days prior to the deadline, with a request that the government send confirmation of the receipt. The government confirmed receipt of 4 of the 6 emails, but not the other 2. And the government's malware software deleted 2 of the other protesters' emails. The protester argued in this case that the government control exception should apply to save those other 2 emails and to get consideration of its proposal. And the GAO denied the protest, just reiterating its sort of longstanding interpretation of the regulation that only the electronic commerce exception applies, because they argued under the government control exception that would not apply, and therefore GAO denied the protest. So again, if you have the option to go to the Court of Federal Claims, if you have a late proposal that the government has rejected and that proposal was submitted via email, not by 5 o'clock p.m. the day before the due date, then the best option is to file a protest of that agency decision at the Court of Federal Claims. And with that, we can turn it over to Katie for the next slides.
Thanks, Eric. So the next case we're going to discuss is a GAO case regarding timeliness, and it's really a cautionary tale when contractors first file a protest with the agency and then file a subsequent protest with the GAO. And this one, this is Marathon Medical. It was a early 2024 case that came out of GAO. In this case, it involved a request for quotes that was issued by the VA in August of 2023. The VA had issued some amendments to the solicitation that included an amendment affirming that the non-manufacturer rule applied. Marathon timely submitted its quote on November 14th, 2023. And then on November 29th, it submitted an agency level protest arguing that the application of the non-manufacturer rule was improper. On that same day, the VA extended the due date for quotes to December 1st. And then on January 17th, the VA denied Marathon's agency level protest. So Marathon then filed its protest with the GAO, and the agency moved to dismiss the GAO protest as untimely. The agency argued that the closing date for submission of proposals served as initial adverse agency action with regard to the agency level protest, and then as a result, Marathon was required to file its protest with GAO by December 11th, which is, within 10 days of that adverse agency action. So GAO held that where an agency level protest challenges the terms to the solicitation, and the agency proceeds to close the period for submission of quotes or proposals, that the protester is on notice that the agency has not taken corrective action to address the protester's challenges. So timeliness for a subsequent GAO protest is measured from the closing date. So I think a lot of contractors or people in general would assume that you have 10 days of the actual decision date out of the agency that it's denying the agency level protest. But basically GAO has treated that closing date and the fact that the agency didn't take corrective action at that time as adverse agency action. And so that 10-day deadline begins on that date. So something to keep in mind going forward if you're considering filing a pre-award agency level protest before going to GAO. Kayla, you can move to the next slide. So the next one we're going to talk about federal supply schedule prices. You can move to the next one, Kaylee. This one was filed by Kaufman and Associates in 2024, and involved a FAR Part 8.4 procurement that was issued by the Centers for Medicare and Medicaid Services. In that case, CMS was seeking virtual training services for the Indian Health Service, and it was a set aside for small businesses. Kaufman was not awarded the contract, and they filed a bid protest with the Government Accountability Office, and they raised numerous challenges in their protest, all of which were sustained. But for today's purposes, we're going to talk about Kaufman's challenges to the awardee's price proposal. And in that regard, Kaufman argued that the agency had not documented a rational basis for finding the awardee's price reasonable, and specifically that the agency failed to evaluate discrepancies between the awardee's proposed labor rates and its federal supply schedule labor rates. Notably, the RFQ here had advised vendors that labor rates proposed were to be in accordance with the GSA schedule under which the effort was being performed, and required vendors to attach a copy of their GSA schedule price list. So unfortunately for the awardee, its proposed rate for one of its LCATs, in this case it was the event coordinator LCAT, was higher than its GSA schedule rate for that LCAT. Nevertheless, CMS had actually found that the awardee's rate to be fair and reasonable and in line with its GSA schedule rates. GAO found otherwise, however, and found that the agency's price evaluation was unreasonable because the proposed rate for this events coordinator LCAT was higher than the GSA schedule rate for that LCAT. And then, as a result, found that it was improper for CMS to issue the order. So it may seem like this seems pretty obvious to most. I think where we've seen things get a little bit complicated for contractors is, oftentimes, most times, the period of performance, say, is not in line with the offer's GSA schedule dates. And so they use maybe a blended rate. But if that blended rate that's proposed is higher than, the rate that's applicable for the base year. So if you take, years 1 and 2, and you blend the rates for those two and you apply it to year 1, that rate's going to be above the GSA schedule rate. And so, in that instance, GAO would find that your price was unreasonably high. So it's just something to consider when you're thinking about those types of things and approaching proposals or quotes in that regard. So with that, Eric, I'm going to switch it back to you.
Thanks, Katie. And Kaylee, we can also go to the next slide here. So the next case that we're going to discuss is, really the same principle as what was at play in Kaufman, that the solicited services for a GSA schedule procurement must be within the scope of the awardee's GSA schedule contract. And this case is just a slight twist because it involves labor categories as opposed to prices or labor rates being outside of the scope of that schedule contract. This is the case of Spatial Front. It was a protest at the GAO, and the GAO decision actually details a somewhat long-running saga of this protest, that this was really the fourth or the fifth protest of this procurement on a similar issue in a number of years. And the protester contended that the solicited services that the agency was seeking to acquire through a GSA schedule buy were outside of the scope of the awardee's FSS or GSA schedule contract. Specifically, that it was not possible for the awardee to provide certain specialized mapping, geospatial, and other specialized IT services within the scope of its contract because its GSA schedule contract and the LCATs described therein didn't contain any of the specialized positions required for that work. And so this is actually an issue that we've seen come up in not only the Spatial Front protests, but a number of protests, and it seems to be appearing with more frequency here, that the agency will put out a solicitation. It will describe certain services that it needs, and those labor category descriptions that the agency includes in its solicitation don't always match perfectly with the labor category descriptions included in the offeror's GSA schedule contract. For example, the solicitation will say, we need an IT specialist with X years of experience and who can perform A, B, and C services. And while the protester or the offer may have a similar labor category, it doesn't match the position description perfectly. And so the Spatial Front decision really stands for the proposition that the descriptions must reasonably be encompassed. The services that the agency seeks to acquire must reasonably be encompassed within those that the offeror offers to the agency. And if they are not reasonably encompassed within the labor category description and the LCAT included in the offeror's schedule contract, then the offer is really offering something that it's not contractually or legally able to offer in response to that solicitation. And so, that's the crux of this case. And GAO's decision has a really good description in this case of the legal standard that applies here and a pretty good analysis of the description in the offeror's or the awardee's GSA schedule contract and the agency's analysis of those issues and why the agency's analysis in that regard was unreasonable. But this all really stems to, after that high-level summary, this all really stems from the legal requirement that for a GSA schedule buy, an agency has to ensure that the services or the goods are quoted are on the schedule contract. And that all stems actually from the requirement to conduct a full and open competition. And if you're not going to if you're going to use the GSA schedule program, you're not conducting a full and open competition. You're sort of limiting those sources. So you can't just allow those limited sources to propose whatever it is that they want. It must be something that GSA has already approved for them to sell to the government. And the way that those requirements have been interpreted by the GAO and by the court as well is that the descriptions of the contractor's quoted labor categories must reasonably include the services that the agency seeks to acquire, and those that are proposed by the vendor. So in Spatial Front, the solicitation required some specialized geospatial IT services. It required folks with specialized geospatial IT skill sets. And the awardee in that case proposed labor categories from, you can see here on the slide, it's management and financial consulting, special item number. It's that corresponding GSA schedule contract that included individuals who design and prepare technical reports, studies, and related documentation. They make charts and graphs to record those results, and they prepare and deliver presentations, training, and briefing. So that's sort of the description that was included in the awardee's GSA schedule contract for what its labor categories of personnel do. And the GAO found, well, that looks to be at a high level something that could reasonably encompass the IT skill sets required, that it actually doesn't apply to IT services, that this description of what those individuals do doesn't apply to the IT services the agency was seeking to acquire. And a big part of that decision was because when read in conjunction with the underlying special item number, that management and financial consulting SIN, they found that those, design and preparation of technical reports was actually in connection with management and financial consulting, not geospatial IT skill sets. As a result of GEO's decision that these types of services weren't reasonably encompassed, the GEO found that the agency's conclusion that the awardee's schedule contract included those labor categories that aligned with the scope of work wasn't reasonable. And what the GEO actually recommended in this case was that the agency terminate the award, as well as then consider those offers with eligible quotations to go forward. So you can see that this is actually a very significant issue, that if you don't propose the labor categories that reasonably encompass the services the agency seeks to acquire, you could essentially be found ineligible for award. And so, the advice to contractors in this point is really make sure that you have your mapping of labor categories nailed down and well thought out before the proposal goes in. Make sure that you can justify how those labor categories align. And if you can provide that explanation, that should help, ensure that the agency can make that determination for you. And with
Eric,
that, Kaylee, we'll move on. Go ahead,
yeah.
Katie.
Well, I was just going to say before you jump on to the next case, I think it's important to note from a protest perspective that this can really be fertile ground for protesters, because in these FAR Part 8 procurements, there's typically very little information that's being provided to contractors, vendors, after awards made. And so a lot of times there's very little to go on in determining whether you want to protest or not. But in this situation, GSA schedules are public. You can pull them, it's in the solicitation. And, you can look to see if you think that there's a gap there between the possible LCATs that were quoted and what was actually required by the solicitation. So it is something to consider from a protest perspective in these FAR Part 8 procurements.
Yeah, Katie, that's a great point. And just to, further emphasize that, so what Katie's saying is the GSA e-library makes publicly available each GSA schedule contractor's offerings, their GSA schedule contract, which includes their labor categories and the description of what those labor categories do. So if you've lost an award that includes some mapping requirement, you as the contractor, you as the offerer, can go look at the awardee's GSA schedule contract. You can go run down the list of their labor categories and descriptions. And if you identify some holes that, hey, we've looked at this and we don't think that any of these labor categories reasonably align to what the agency was seeking to procure, like Katie said, that's a really fertile ground for protest, and can be an outcome determinative decision, because that awardee could be found to be ineligible for award in that circumstance. And so with that, Kaylee, now we could move on to the next slide. And we can move on to the next as well. So we did promise we'd talk about one FAA protest. This is the protest of AdSync Technologies. And why we bring this case up is actually the ODRA rarely issues sustained decisions. We don't have the statistics from the ODRA. They don't put the statistics out in the same way that the GAO and the Court of Federal Claims do. But, anecdotally looking at the cases and reviewing them as we do, there are relatively few sustains, and we'd say, fewer sustains at the ODRA of FAA procurements than there are at the GAO or the Court of Federal Claims. And so the protest of AdSync Technologies was one of those kind of rare sustains in the last year here. And it's actually a really good protest decision. There's a question just briefly here, what is the ODRA? And so for the benefit of the audience here, if the Federal Aviation Administration is conducting the procurement, the protest cannot be filed with the GAO or the Court of Federal Claims. It must be filed with the FAA's Office of Dispute Resolution for Acquisition, that is ODRA. So that's what we keep referring to here. And so the protest of AdSync Technologies is a good decision because there are a number of different protest issues that were raised in the protest, and the ODRA went through each of those protest issues and gives a good statement of the law for each of those issues, and just a good way to kind of issue spot. If you are ever in an FAA procurement and you read this decision, you can see what are some of the issues that the ODRA will look at, what are some of the issues the ODRA will sustain, and what are some of the issues that the ODRA won't consider in a bid protest. And so in this procurement, the Federal Aviation Administration was soliciting new hardware, maintenance, and system support to update its tower simulation systems. Those are the systems that are used to train air traffic controllers. And this case actually involved the unequal access to information OCI, which was that these tower simulation systems previously relied on a proprietary software from a company called Adacel. Adacel was the awardee of this contract. And AdSync challenged that that software going forward in this procurement was unknown to it. It did not know what software would be used, but made an allegation that Adacel did know that, and that constituted some unequal access to information that helped Adacel in the procurement. The ODRA sustained the protest on that basis and found that the FAA created an unequal access to information organizational conflict of interest related to this proprietary software that gave the awardee some competitive advantage. And there's some good information in the decision about what constitutes unequal access to information and what will not save an agency from an unequal access to information OCI challenge, including that, saying that it gave the information as part of market research is not a safe harbor for disclosing that information unequally among the offerers. There was also, arguments within the protest about Buy American Act compliance. I think that's a good issue in this decision, just to see that the ODRA considers that an issue of contract administration and would not really consider that too deeply in a protest. It will be more of an issue as to whether that contractor complies with the Buy America Act in the performance of the contract. The ODRA then went through other challenges to the evaluation of the management and technical proposals that were submitted and sustained the protest on those bases, as well as in the ultimate best value trade-off decision. And I think it's just important to read these cases if you're ever if you're ever in a procurement with the FAA, because, well, we all tend to know and love the FAR, and we all tend to know and think about procurement in terms of the FAR. The FAA has slight differences in its acquisition management system policies. It does not use the FAR, and while that AMS guidance tracks the FAR in a number of ways, there are some differences as it concerns the evaluation of price and price realism, what must be documented in evaluation conclusions, and in the analysis of OCIs. And so that's really why we highlighted this decision. It's just one of the rare sustains out of the ODRA that we don't typically see all that often, and gives a good overview of the landscape of an ODRA protest. With that, we can move on to the next slide. And I think I covered this, so Kaylee, we'll move one more and we can jump back over to Katie.
Thanks, Kayla. Next we're going to talk just a little bit about protest tips. This actually can be an entirely separate webinar in and of itself, but we'll just touch base on some of these points today, as we're closing up here. But if you're the awardee and you want to vigorously defend your contract award, it's really important to get your attorney involved early in the process, as soon as you are aware that a protest has been filed or that you think one may be filed. And it's also important to reach out to the agency to find out, what they know, if they know anything, as far as if a protest is filed. You can ask them to get a redacted copy of the protest, if they'll provide it to you. If not, again, you can reach out to counsel. They may be able to connect with agency counsel and get a copy of it, so on and so forth, so you understand at least what the initial bases of protest are, and you can make a decision as to whether or not you want to intervene in the protest, which in most situations we suggest that you do for various reasons, not the least of which is to make sure that your confidential and protected information is not released, not only within the context actually of the protective order, if there is one, because you want to make sure obviously that that's not out in the world, but also so that, if the agency is going to be producing documents in the protest, whether that's at the Government Accountability Office, typically at the Government Accountability Office, where you can limit the production of documents, or at least try to, talk to the agency counsel about trying to get your information, the information that it plans to submit as part of its agency report, limited or redacted, so that the other side doesn't have, an opportunity to look through everything to determine whether or not there's additional supplemental protest grounds, and basically go on a fishing expedition. So with that, we can go to the next slide, Kaylee. So, and if you're on the protester side, you obviously also want to get your counsel involved early, just to talk about, whether it makes sense to do a pre-award protest. If there's ambiguities or current concerns that you have with the solicitation, those typically need to be protested prior to submission of proposals. So it's important to make sure that you aren't missing a deadline, and that you're kind of out of luck if you don't protest prior to the submission deadline. Another tip is to get as much information as you can through debriefings. And, we see a lot of clients not necessarily ask for post-award debriefings when they're the awardee, because they think, oh, well, I'm the awardee, there's nothing I need to learn, except for the fact that if there is a protest that's filed, and say the agency is going to do open discussions, so on and so forth, request, issues an amendment, request revised proposals, you don't have the same benefit as those that have requested the debriefing. So it's important to get all of that information, if there's weaknesses and so on and so forth, as part of your debriefing process, so that you're prepared if you need to be at the end of the day. And then something else, strategizing as far as picking whether or not you want to be at the court or at GAO, and there's various factors that go into that. And Eric, maybe you want to touch base on kind of why one would pick the court over GAO.
Yeah, Katie. So there are differences between the GAO and the Court of Federal Claims. I'll start with the GAO here. First, if you are in a task order competition or a task order procurement, in all but some rare circumstances, the GAO is going to have exclusive jurisdiction over a protest involving a task order. So you may be limited to go to the GAO in that case. We most often see clients want to go to GAO for a couple of reasons. So one is there's an automatic stay of performance of an awarded contract. That means an agency cannot go forward with an awarded contract in a procurement if you file a protest within certain timeframes. And if you get that automatic stay, that can be beneficial not only in ensuring that you get meaningful relief, but it can also be extremely beneficial to incumbent contractors who very often in that situation will receive a bridge contract for the protest period, because the agency cannot go forward with that award. Conversely, if you're at the Court of Federal Claims, there is no automatic stay of performance. We've seen agencies voluntarily agree to stay performance of the awarded contract when there are protests filed at the Court of Federal Claims. But recently, agencies have been not agreeing to voluntary stays as frequently, in which case the protester would need to file a motion for a preliminary injunction to get a stay of performance. And those are fairly resource intensive. They're difficult motions to win on, especially at the early stages of the protest process. Another, difference here is GAO is required by statute to resolve protests within 100 days. So you will generally get a quick decision. The decision typically comes out right around that 100-day mark at the GAO. The Court of Federal Claims is not statutorily required to decide protests in any set amount of time, although typically we see court protests decided within about 120 days or so. So not all that much longer, but they can drag out longer in certain circumstances. I think another main difference here is the record on review, and this is one that tends to typically favor going to the Court of Federal Claims. So at the GAO, the agency is required to produce the agency report, as it's known, and that report consists of the quote-unquote relevant documents, those documents that are relevant to the protest grounds, and the agency gets to decide in the first instance which documents are relevant to the protest grounds. Oftentimes, as a protester, you don't know what you don't know, so it's difficult to challenge the agency's sort of relevancy determinations. Conversely, at the Court of Federal Claims, the agency is required to produce the full administrative record, and that is every document that it produced considered in the course of its procurement. And so oftentimes we've actually seen, even recently, there are cases that are initially filed at the GAO. The protester loses at the GAO and then goes and refiles its protest at the Court of Federal Claims, gets access to more record documents, and actually is successful at the Court of Federal Claims as a result of the additional documents that it has been able to view and receive over there. And so those are the main differences between the GAO and the court. There are other differences, in terms of costs and resources that it requires to go through each process. But I think from a strategic perspective, that really hits on the differences between the two forums. And it's something that you just need to discuss with your attorney at the outset. They're largely dependent on the facts and circumstances of your particular procurement and the protest that you may intend to file. And, as attorneys, we can help guide you through that process and pick the best forum to file your protest that gives you the best chance of success in that protest.
Great, thanks, Eric. And then just to wrap up here a little bit, as far as picking your battles and trying to decide what challenges you want to make or should make, consider what those most frequently sustained protest grounds are. Unreasonable technical evaluation, flawed discussions, maybe the agency conducted unequal or failed to conduct meaningful discussions, whether the cost or price evaluation was unreasonable, and whether the agency treated offers unequally. Those are all very common protest grounds, but obviously it's important to talk to your counsel to determine if any of those are kind of on the table as far as challenges you can make. Again, that LCAT argument in a FAR Part 8 procurement is also, I think, a fertile ground, as we've talked about earlier, as far as potential protest grounds. So let's see, I just checking.
And Katie, I think just to kind of wrap this up from my perspective, in the current administration, there is a heavy focus on cost to the government. Price might be something that we see more relevant in protests going forward. If you're the low priced offer, even if you may not be as high technically rated, I think that could be something that we see become more impactful in protests, not only from a sustained protest perspective, but also from an agency's willingness to take corrective action or desire to take corrective action to possibly get a lower priced offer in the door. And just on that note, with the current state of the administration and where things stand from a contractual perspective, I think a lot of these contract opportunities are becoming more and more valuable to contractors, which makes the protest process more useful tool if you haven't received an award that you believe you should have received, or that would be, particularly valuable to your company. But as well from an intervener perspective, to vigorously defend the award, like Katie said earlier, in this current environment, that's something that, could become even more useful and should be something that you consider for that reason as well.
Thanks, Eric. And then it looks like we have a question here. If the incumbent contract has expired, can GAO still require a stay of performance for the awardee? And the answer to that is yes. It's really irrelevant whether or not there even is an incumbent contract. The stay of performance is required for the awarded contract regardless, unless the agency has decided that's going to override the stay. So something to keep in mind there as well. So thank you all for your time today. We really appreciate it. If you have any questions, please feel free to reach out to either me or Eric. We're happy to help you as we can, and you should be getting a copy of these slide presentation in your email. So thank you all, and hope you have a great day.
Thanks all. And if there are any additional questions, feel free to reach out, or if we've missed some, we'll follow up. We appreciate it.